Good afternoon. The Appellate Division First Department is now in session. Welcome to our virtual oral arguments for Wednesday, January 13th, 2021. I will now call the calendar for today. People versus Danny Ponder. Appellant.
Good afternoon, Brittany Francis, Center for Appellate Litigation on behalf of Mr. Danny Ponder.
Okay, you have 6 minutes and 2 for rebuttal.
Thank you.
Respondent people?
Good afternoon, Andrew Seawald for the people.
Okay, and thank you. You have 6 minutes. The next case is DeJesus versus Bell Apartments, submitted. H. Joy versus Tyrone M., submitted. Bortunio versus New York State Urban Development, the appellant Schindler Elevator.
Is Steve Efron for defendants appellant Schindler and Midland.
Okay, you have 5 minutes and 1 for rebuttal. And the
Thank you.
respondent, you're welcome. Respondent, New York State Urban Development.
Christopher Yevchadek for the New York State Urban Development Corporation.
Okay, and you have 5 minutes. Next
Thank you,
case.
Your Honor.
Welcome. Rosenbaum versus Myers, the appellant.
Good afternoon, Your Honors. Benjamin Ali for Plaintiff Appellant Rosenbaum.
Okay, you have 5 minutes and 2 for rebuttal. And for the respondent?
For the respondent, Robert Smith, Your Honor.
Okay, good afternoon. You have 5 minutes to argue. The next case is Lynn versus New York City Department of Education. Appellant Lynn.
Fong Lin on behalf of IBH.
Okay, Mr. Lynn.
Yeah, petitioner appellant.
Okay, yes, you have 6 minutes and 2 in rebuttal. And the respondent?
Good afternoon, Your Honor. Respondents and cross appellants, Wamake GB here for those parties.
Okay, and you have 6 minutes for argument. Okay?
Your Honor, could I reserve 1 minute for rebuttal as a cross appellant?
Sure, absolutely. I'll mark that down now. Thank you. The next 2 cases are People versus Randolph Smalls. Both of those cases are submitted. Jackson versus 160 West End Avenue. Appellant?
She was on the line audiologically. I'm Annette Hesapidis for the respondent and cross appellant.
Okay.
Ayala for the defendants.
Okay.
Yes.
All right. Thank you. You both have 5 minutes for argument. Okay.
Thank you.
You're welcome. The next case is Morales versus Gross. That is submitted. Next, Trinity, New York City versus MTA, New York City Transit. Appellant.
Yes, this is John Nikolic for the appellant, MTA and New York City Transit.
Okay, Mr. Nikolic, you have 6 minutes and 2 for rebuttal. Respondent, Trinity, New York City Hotel.
Good afternoon, Your Honor. Bill Freed for Trinity. Your Honor, my co-respondent has graciously offered to give me 2 of his 4 minutes, if that is permitted by the court.
Well, if you need it, we'll see.
Necessary. Hopefully, I will not need it, Your Honor.
Okay, fine. Thank you. And respondent Rinaldi.
Jason Jacobs for Rinaldi.
Okay, so you have 2 minutes now.
Yes, thank you.
Okay, the next case is R&R Third Properties versus Greater New York. That case is submitted. Amanqua versus Department of Education is submitted. Milligan versus Tudor Perini is submitted. Castro versus 510 West is submitted. CIT Bank versus Gould is submitted. The next case is Senius versus Mount Sinai and Lenox Hill. Is the respondent here? The appellant, excuse me? Appellant.
Yes, Your Honor. I'm Anastasia Senius. I'm the appellant in both cases.
Right. Okay. So in the case that involves, good afternoon, in the case that involves the hospitals, you have 6 minutes and 2 for rebuttal. respondent, Mount Sinai respondents?
Patrick Lawless for Mount Sinai, St. Luke's Roosevelt.
Okay.
Respondents.
All right, you have 4 minutes, and the Lenox Hill defendants?
Dan Ratner for Lenox Hill.
Okay, and you have 4 minutes. And the next case is Professor Xenius versus the City of New York and FDNY. You're the appellant there too. You have 5 minutes, Professor Xenius, and you're welcome. And the respondent, City of New York and FDNY. Counsel respondent?
Yes, Your Honor. Daniel Matzabran for the respondents in this appeal.
Okay, and you have 5 minutes. I hope that you were notified, as I requested by the clerk's office, that your case is going to be argued first on the calendar today, because one of the judges, Judge Schulman, had to recuse himself from that case, from those cases, and Judge Gish is vouched in. So we're going to hear argument on those 2 cases first. Just to complete the call of the calendar, Barsante versus UBS Asset Management, that case is being submitted. So the first case to be heard is Xenius versus Mount Sinai and Lenox Hill. And Judge Schulman is going to be leaving now, and Judge Gish, I believe, is on the call. So, Professor Xenius, whenever you are ready, you may begin your argument. I just want to remind all the other attorneys to please and parties to please make sure that you mute your microphones until your case is called, and please make sure not to talk over each other or over the judges, which we would never want to do, but especially now that we're working remotely and we're all doing the best we can. Okay, sorry, Professor, you may begin your argument. Good afternoon.
Thank you, Your Honors. Good afternoon. Your Honors, this action alleges negligence in ambulance dispatch and response and treatment of the decedent, my father, resulting in his pain and suffering and ultimately his death. The issue before the court is whether all allegations are time-barred, particularly ambulance dispatch, for which there is no precedent in the state of New York. The trial court found no precedent in New York ruling ambulance dispatch as medical malpractice. The trial court found only a single split decision case in Michigan, which it used to dismiss this action in its entirety. The defendants, for their part, failed to present any statute, case law, or even expert testimony to prove that such precedent should be created. Respectfully, the matter should be heard by the higher courts. To the contrary, in New York, there is precedent for ambulance company actions, lateness in medical care, and incompetence to be ruled as negligence. In Mancuso v. Calida, the Fourth Department ruled that an ambulance company's failure to, quote, communicate significant medical findings to a treating physician sounds in ordinary negligence, end quote. In Clarity v. Fromberg, a surgeon was late to deliver a pregnant woman in a hospital, leaving the baby without oxygen for 21 minutes. The Second Department ruled the lateness was negligence and governed by the 3-year statute of limitations. In Bleiler v. Bodner, this court determined that claims against the hospital for failure to provide competent emergency room personnel and promulgate proper regulations were claims for negligence, and therefore subject to the 3-year statute of limitations. By what logic, then, does the trial court rule that in this incident, every act from the moment of the 911 call to the moment of my father's death was medical malpractice? In this case, the failure to follow protocols speaks to the competence of the personnel and the failure of the ambulance company to promulgate rules, which this court has deemed sounds in negligence. There were no show or late. They didn't call medical command for direction from a doctor. They didn't administer required medications. They didn't transmit the data from the life support monitors to the hospital, not even a single EKG in this cardiac emergency. One responder stood idly by chatting with our neighbors. Another never left his vehicle. This sounds in incompetence and is ruled by the 3-year statute of limitations. The Court of Appeals does not even recognize first responders as medical professionals. In Applewhite v. AccuHealth, the court ruled, quote, EMTs cannot be realistically compared to proprietary medical professionals whose licensure requires extensive education and training, end quote. If the Court of Appeals does not recognize first responders as medical professionals, A medical malpractice statute of limitations cannot apply to them broadly for all actions when even physicians do not receive such benefit from the court. Finally, there's longstanding precedence in New York that when an act is obvious to a layperson without need for testimony from a medical expert, it sounds in negligence and falls under the 3-year statute of limitations. An ambulance not showing up or arriving 21 minutes late to a life-threatening emergency, responders failing to follow rules or standing idle is obvious negligence, incompetence, and abandonment to everyone. That's why it makes headlines when it occurs. Defendants Mount Sinai claim that the idea a layperson can understand a late ambulance is negligent is absurd. Before ruling for the defendants, I would ask the layperson members of this court to consider if you would think it absurd if it happened to you. There is legal reasoning for the court to allow this case to stand without even considering the issue of whether ambulance dispatch is medical malpractice or not. First, under New York state law, it's well established that the clock on statute of limitations starts when a claimant has legal standing. In the case of a decedent, legal standing arises with the granting of letters of administration, which gives the estate the right to legal action. Even in Michigan, where the trial court went to find a case to dismiss this action, the law there states that the statute of limitation accrues after the granting of letters of administration. Second, New York State's statute allows the claim for
We're having a, I'm having a little problem hearing you.
the file.
You're sort of fading out.
Years of death. Monetary damages from the father.
Professor, your connection may be a little
Can you
weak.
hear me now? Your Honor, can you hear me now?
Hello? Vaguely, yeah.
Can you hear me now, Your Honor?
Yeah, a little. It's a little better.
Okay. Second,
I want to, this is Judge Gish. I want to ask a question about your claim that the statute of limitations doesn't run until letters are granted. So can you envision a situation where somebody dies and there may be a cause of action as a reason for it, but no letters are applied for years and years and years? Are you telling me that under your scenario that the statute of limitations doesn't run? Is that the law?
I'm saying that, as I understand the law, the courts have said a claim does not accrue until a claimant has legal standing.
And now I'm asking you to apply it in the context of letters, because we all know that there are cases where personal representatives aren't applied for it in the surrogate's court for years and years after a decedent's death. So it's your understanding that there is no claim, even if years pass before letters are issued. Is that your claim? Is that your argument?
My claim is the estate cannot apply for any claim until it has legal standing. If it takes months or years, that's for the court.
Yeah, but that may not have nothing. That has nothing to do whether you have standing. Standing and the statute of limitations are different. They're different concepts.
That's for this court to decide, Your Honor.
Well, that's why I'm asking the question. Okay, thank you. I think I understand your argument.
Okay, thank you. Professor, you will have 2 minutes for rebuttal. We're going to hear from the respondents now, okay?
Okay.
Thank you. Mr. Lawless, on behalf of the Mount Sinai defendants.
Good afternoon, Your Honors. Patrick Lawless for Mount Sinai defendants. The plaintiff's claims clearly sound in medical malpractice. They specifically relate to the treatment administered to the decedent. If you review the bill of particulars, they all sound in medical malpractice.
Let me ask a question. This Judge Gish again. You will allow that this seems to be an issue of first impression?
I think the issue of whether delays sound in delay in rendering treatment sounds in medical malpractice, not in this specific instance, but just in general is not first impression, because there are plenty of cases.
No, but
that
that's,
have
you know,
held.
that's not what I'm asking. I'm asking about late ambulances. That's the case. Not delay in treatment by a doctor or a nurse or somebody else. If the ambulance delays in treating, that we don't have any clear authority that says one way or the other whether that's malpractice or negligence, do we?
I think not from the appellate division. The lower court did cite to a case from out of state, but again, I think it's analogous to those situations, not with an ambulance, but it's analogous to situations where in hospitals and in emergency rooms there has been a delay in treatment because it specifically relates to medical care and not ordinary negligence, and that expert testimony would be required to determine whether or not a standard of care was met.
Meaning that there's some medical evaluation about which emergency gets an ambulance at what time? Is that what we're talking about?
It does relate to the treatment, and it depends on the information that's provided, what the EMTs, what type of assistance they provide. In this case, for example, in this case, you had two different teams. You had an advanced life support team, and you had a basic life support team, both dispatched to the call. So yes, it does. It actually does relate to medical treatment and the type of emergency that they're responding to.
Okay.
If there's no other questions on whether or not the medical malpractice statute of limitations applies, I just like to also add that it was not reached by the court below, but as an alternative grounds for affirmance, Mount Sinai submitted evidence that there was no breach of the standard of care, and in opposition to that showing, the plaintiff failed to raise an issue of fact. The so-called expert affidavits that she submitted weren't submitted in proper form. They weren't duly sworn. They weren't signed. And the experts didn't even demonstrate that they were qualified to rebut Mount Sinai's experts' assessment that no standard of care was breached.
Okay, anyone have any more questions? All right, thank you, Mr. Lawless. Mr. Ratner, we'll hear from you.
May it please the court. In answer to Judge Gish's question, it does seem that there's not a case directly on point in New York. However, we did cite one case in our brief where the issue was the failure to answer a call bell for a hospitalized patient in a timely fashion, and the court in that case specifically held that was an issue that raises as a medical malpractice claim, the sort of the delay type of concept. The cases where negligence standards have been applied or where it's a failure to communicate a very basic piece of information. So there was one EMT case where a medication list was not handed over to the hospital, and that was fairly basic. Here, however, if you look at the pleadings, it's clear that the plaintiff herself is alleging various departures from medical standards of care, all of which would require an expert to weigh in on, because it's not as simple as failing to respond in a timely fashion to an emergency. You have to understand what information was provided to the dispatcher and then what happened after that. And here there were 3 ambulances that arrived at the scene, all providing at different times, providing various levels of care. So I think that it falls comfortably within the medical malpractice realm where you're arguing that there's a delay in treatment. So that will be the argument there. I really don't have anything else to add other than what Mr. Lawless said, to be honest with you. So,
does anybody on the panel have any further questions? Okay, Professor, you have 2 minutes in rebuttal, okay? Professor Senius, it looks like you might be frozen. Is there somebody on here who can reach her by email? Is there a tech person on this call?
I can try to email her. I'm the counsel for the city in the other case, and I can see if maybe she can dial in.
Yeah, could you? That would be very kind of you, Mr. Brown.
I'll do that right now, Your Honor.
Thank you.
I have just emailed her. I'll let the court know as soon as I hear back.
Yeah, I mean, I can't really go to another case because we have this vouch-in situation, so I really got to get her back on. And I thought our tech people.
Judge Kapnick,
Yeah.
if too much time elapses,
yes,
you can text me and I'll come back in if you want to go forward on your calendar. I'll be amenable to whatever works for you.
Yeah, thank you. I'm so sorry, Justice Gish.
That's fine. We this is the world we live in now, right?
Yeah, I thought tech people are supposed to be on the call to help out. Oh wait, no, I see somebody. Why isn't he on?
I'm working on reaching out to her, Judge Kapnick.
Oh, okay. Who's that?
This is Stacy.
Oh, okay, Stacy. Thank you. Judge Gish, give it a minute or so. If not, I'm so sorry.
Sure, you don't have to apologize for me.
Okay, she's apparently back.
Your Honors, I apologize for the technical difficulty.
Okay, well, we're now on your rebuttal. I hope you heard Mr. Lawless and Mr. Ratner. Do you have anything you want to respond to on that case?
My response, Your Honor, is that the defendants provide absolutely no evidence, no case law, and no expert testimony that would create precedent that ambulance dispatch delays are medical malpractice. None. I would like to make a few points with respect to summary judgment.
What? Are you there? Miss Professor Exenius? Okay.
Yes,
oh, okay. I don't know what the problem is, but you want to finish up on this case so we can get to your next case? Anything else you want to say in terms of this case?
Yes, Your Honor.
Okay.
I'd like to say with respect to my experts, both expert affirmations were sworn statements, sworn affirmations, and properly submitted with their credentials and are part of the record. So it is wrong to say that they were not properly submitted. Both my experts contradict Mount Sinai's expert and state that my father could have survived with timely and proper care. Now, with respect to summary judgment, the trial court ruled that the failure of the first ambulance, a Mount Sinai ambulance, to arrive after dispatch was, quote, inexplicable, identifying a critical question of fact that precludes summary judgments for the respondents. Lenox Hill provides no expert testimony at all. And the idea that Mount Sinai's expert should be applied to them should not be accepted by this court. He makes no statement with regard to Lenox Hill and no statement about whether the outcome could have been different with a more timely response. Finally, the defendant's claim that medical records are irrelevant is plainly not true. The complete record is necessary to determine proximate cause of injury. When and whether cardiac data was collected in the field and transmitted to the receiving hospital is highly relevant in a cardiac emergency, and the courts have already determined that critical medical information sounds in negligence. Relevant or not, why do the defendants adamantly refuse to provide the data to me? I have a legal right to the complete medical record as my father's daughter and administrator of his estate, while withholding medical records is unlawful and grounds for striking their answers. Summary judgment should be denied here as the defendants have provided no proof they're entitled to it, and my motion to strike their answers should be heard. Thank you for the additional time, Your Honors.
Okay, so now we're going to get to the second case, Professor, where you're also the appellant. You have 5 minutes on that one. So if you want to transition, that's the case against the City of New York and the FDNY. You seem to be on mute.
I'm ready,
Okay.
Your Honor.
Okay, go ahead. You may start.
Thank you. This is a wrongful death action for negligent EMS dispatch and treatment by the defendants. The issue before the court is whether a special duty arose to my father. The incident is nearly identical to Applewhite v. AccuHealth and City of 2013, where this court denied summary judgment to the city. In my case, as in Applewhite, a 911 call was made for a family member who was not breathing. The city responders arrived without oxygen and without a defibrillator, took control, and failed to transport to a nearby hospital, choosing instead to wait for an ambulance, which arrived over 21 minutes after the 911 call. In my case, the 911 operator also made a concrete promise to me that we are on our way, and I felt reassured knowing there was a firehouse across the street. The certified documents show that this was actually a false statement. An ambulance was not dispatched for another 3.5 minutes, and the FDNY crew took 9 to 16 minutes to arrive from the firehouse across the street. They could have walked over with oxygen and a defibrillator in seconds. They could have transported my father to Roosevelt Hospital a few blocks away in minutes. They could have called for help immediately. They didn't. Whether it was reasonable for us to expect any of this is a question for a jury. All they did was administer chest compressions and wait for an ambulance, as sworn in my mother's affidavit, which the trial court overlooked. In Applewhite, the Court of Appeals ruled that because the FDNY EMTs continued performing CPR while waiting the arrival of an ambulance, this posed, quote, a question of fact as to whether the EMTs, through their actions or promises, assumed an affirmative duty in deciding to have ALS paramedics undertake more sophisticated treatment rather than transporting to a hospital. It is possible that it was reasonable for Tiffany Applewhite's mother to rely on the EMTs since she was not informed that it would take about 20 minutes for the ALS ambulance to arrive, end quote. The FDNY responders in my incident did exactly the same thing as they did in Applewhite. And as with Tiffany's mother, neither was I told that it would take over 21 minutes to get an ambulance to my father. Whether the city understood the urgency of unconscious and not breathing, or what the FDNY responders said or did not say while they were first on scene, is a question of fact. The city failed to appear for a court-ordered deposition. Neither did the city ask me in my deposition what that first arriving crew said or what I would have done differently. The city's argument that I did not identify specific alternative avenues for protection should not be accepted here, as it was not accepted in Applewhite. In Applewhite, the court ruled, quote, although it is true the plaintiffs have not specifically identified any other available avenues of protection, the allegations raise the question of whether the EMTs may have lulled plaintiffs into a false sense of security, end quote. Moreover, I did identify alternative avenues in my affidavit, which the court overlooked. We were in Times Square, in the very heart of the city, with ambulances, doctors, and hospitals all nearby, indeed, everywhere. We had options. If they had told us it'll take over 21 minutes to get you an ambulance, and we won't even have oxygen for you until then. But they didn't. The city made false promises and took control of this life-threatening emergency, then took actions negligently. If my claim is not convincing enough, then let a jury decide, as in Applewhite. The trial court also erred on a number of fronts. First, the court ruled that I did in fact claim special duty in both notice of claim and in the verified complaint. My argument was just not convincing enough. Respectfully, as a matter of law, the court cannot dismiss my case because of the insufficiency of the opposing arguments, because I didn't say things the right way or argue as well as a lawyer would. Second, the trial court ruled that EMS workers can in fact be held liable for negligence if they administer treatment, but then ruled there was no evidence the FDNY treated here, overlooking the city's own certified documents that prove FDNY was first on scene and first to treat my father, not Lenox Hill. That is the fact, whether we knew it at the time or not. Third, the trial court overlooked its own court order assigning a special referee to review and report on discovery, and then overlooked its order as well as the city's discovery evasion. The city's refusal to comply with discovery demands for medical records they certify are in their possession, documents I have a statutory right to, is unlawful. And the city's refusal to comply with court-ordered discovery and deposition compromises the authority of the court. This is grounds for striking their answer. Instead, the trial court granted the city's summary judgment when all they prove is that the 911 operator promised me we are on our way and that I relied on that and all it implied to our detriment, and a decent man died. Thank you, Your Honors.
Thank you very, very much. Mr. Matza-Brown, you have 5 minutes. Thank you.
Thank you, Your Honor. May it please the court, Daniel Matza-Brown for the city. This is undoubtedly a sad case, and our best wishes do go out to Professor Zinius and her family. Under binding precedent from this court and from the Court of Appeals, the court below correctly dismissed the lawsuit because Ms. Zinius did not plead, nor did she offer any evidence to establish that the city owed a special duty here. Furthermore, the city was alternatively entitled to governmental immunity in any event. First, on the issue of special duty, her claim of special duty here rests on 4 vague words that were allegedly uttered by the call responder to her. We're on our way. Contrary to the argument she just made to this court today, Applewhite does not deal with words, vague words of that nature. Applewhite is about what EMS responders did on the scene in terms of providing treatment versus providing transport. It's an entirely different case. As limited by the notice of claim in the complaint here, Ms. Zinius's action is about how the 911 call responder responded to her call. Her notice of claim says FDNY did not show up. Her complaint says the same. And so those are the claims that the city has litigated. And focusing on the call response, a vague statement such as we're on our way is insufficient to create reasonable reliance as a matter of law. We can look at decisions from this court and from others that find vague comments of that nature legally insufficient. In DiNardo, the statement that something was being done to address an abusive student was too vague to support a special duty. In Brown versus City of New York, the statement, I am going to take care of it, by a police captain was again too vague to generate justifiable reliance. And in Holloway, from the second department, the call operator's statement that an ambulance will be there as soon as possible was likewise found insufficient to create a special duty. The same outcome is warranted here. Turning to Ms. Zinius's claimed interpretation of we're on our way, the city urges that that interpretation is unreasonable as a matter of law. Ms. Zinius's claim of detrimental reliance hinges on her belief that we're on our way means that an ambulance would have been there within a matter of minutes. It also hinges on her knowledge that a firehouse was near where her father was ailing. But the fact of the matter is that the call operator made no such assurance about timing. And the notion that in the absence of such an assurance, when we are in a city of millions of people with numerous emergency calls at all times, with traffic in Times Square, with numerous other considerations that this court, I think, was referring to in the argument with the hospitals just before this one, it is unreasonable to assume that a statement of that nature means that help will arrive in a matter of minutes. For that reason, she has not shown detrimental reliance of the sort necessary to establish a special duty.
Does anybody on the panel have any questions for counsel? All right, well, we have your briefs and we thank you very much for the arguments, all of you, and we will certainly take a further look at all these issues. Thank you and have a nice afternoon.
Thank you, Your Honor.
Thank you, Justice Gish.
Thank you,
for your
Justice
patience.
Kapnick and colleagues. I take my
Okay.
leave.
Judge Moulton, will you send a text for me?
I did.
Okay, thank you very much. The next case is going to be People versus Ponder, and you can get ready, but we're just waiting for Justice Shulman to get back onto the teams. Up, and there he is. Excellent. Okay, Ms. Francis, you may begin.
Yes, thank you, Your Honor. May it please the court, my name is Brittany Francis and I represent appellant Danny Ponder. The police in this case did not have probable cause to search a closed compartment in Mr. Ponder's trunk.
So let me ask you something, Miss Francis. We have two cases from our department, People versus Villette and People versus Mina, and they seem to say exactly the opposite of what you just said, that in fact, the police had probable cause under these same types of circumstances when they smelled marijuana in the car to search the vehicle under the automobile exception, even including in a search of the trunk. So how do we get by those cases, according to you?
Yes, so a couple of things, Your Honor. The first thing is that Villette and Mena both deal with searches of trunks and not closed compartments in the trunk. And so even if there were one-size-fits-all rules, those rules would not control here where we're dealing with different circumstances. The second thing to note is that the cases that the prosecution cites and the cases we cite are all fact-bound because that's what the Fourth Amendment demands, circumstance-specific analysis. There are no one-size-fits-all rules. And in each of the cases the prosecution cites, the police had a specific basis to believe that there was contraband in the trunk. In fact, in U.S. v. Ross, the Supreme Court case we've been dealing with here, the police there had an affirmative basis to search the trunk in Ross because they received information that the defendant had been selling drugs out of his trunk. The precedent all points toward circumstance-specific analysis and a nexus requirement. So a connection between the scope of the search and the particular criminal activity suspected. And here, there's no dispute that the police only ever suspected Mr. Ponder of smoking marijuana with his friend in the passenger compartment. And what they found when they searched the car was consistent with that suspicion. They found a personal use quantity of marijuana in the center console. Nothing about what they found in Mr. Ponder's car elevated their suspicion beyond this idea that he was smoking with his friend. It's also important to recognize that search and seizure law is not just a matter of where contraband could be held, where it could fit. Otherwise, every search predicated on drug possession would be deemed permissible. We have to have an affirmative basis to go into the places we're going. And here, there was no basis to suspect Mr. Ponder's trunk.
Can I interrupt you for 1 minute, Ms. Francis? Stacy, are you still on this call? On this team? Stacy, Judge Mazzarella is having a little problem with her connection to the internet, so I'm not sure. She may have not be on this, and we would have to wait a minute. Can you see if there's something perhaps you can help her with, please?
Okay, I tried to send her an additional request, and I will try to troubleshoot.
Okay, boy, I'm sorry, everybody. I'm not used to having so many all these problems. I guess people's internets are all weak today. I don't know what that's about. So I just need you to wait a minute because we only have 4 judges on the panel. So if one isn't here, that's a problem.
I understand.
I'm sorry.
Thank you.
sorry. And I can't do anything.
I understand.
Okay, I think Judge Mazzarelli is going to call in, so you
Hello?
won't see her.
Hello?
Judge Mazzarelli, are you on the phone there?
Yes, I am.
Okay, well, I'm sorry we won't get to see you, but you can hear us. If you have any problem, please let me know, okay?
Okay, thank you.
Okay.
I don't know what happened, but
Yeah, who knows? We have little control over these things. Okay, so Miss Francis, we're sorry we had to interrupt you. You were telling us about the fact-based analysis and perhaps you'll have another 3 minutes to tell us whatever you would like to tell us. I'm sorry to have interrupted your train of thought.
No worries, Your Honor. Thank you.
Okay, thank you so much.
So the question in this case isn't whether contraband could be hidden in the trunk, because the answer to that question is always yes, that's always possible. The question is whether there were any affirmative indications in this case that this trunk contained contraband. And if the answer to that question is no, had the quantity of marijuana the police found been larger? Had there been?
Well, can I just stop you there? I'm sorry, but so does this require an analysis by the officer at that particular second as to, well, is this a personal use amount? How much is enough? How much is too much? How, that's a tough call to be making at that time. So do we need a specific rule for that or what? So that we know what's a personal amount?
Well, Your Honor, at the time, the officer said that he recognized that this was a small amount of marijuana, and in fact, the only thing he ever attempted to charge Mr. Ponder with was the violation, not a misdemeanor for a larger quantity. So I think this is something that officers are equipped to do, but it's not tied just to the amount of the marijuana. It's the whole circumstances that the officers confronted. And here, what they found was two friends smoking marijuana outside of a Popeyes on a Saturday night. And while he said that he smelled smoke when he walked up to the car, he never found anything in the car indicating that what he observed initially was wrong, that there was
Counsel,
some broader criminal enterprise.
Sorry to interrupt. Can you hear me? What do you think would happen if Detective Tedeschi presented those facts to a judge and asked for a warrant? Would he get the trunk? Would he be allowed to search the trunk?
Your Honor, I don't think that he would, because there was nothing raising suspicion specifically about the trunk. There was no access to the trunk from the interior. Nothing about the car was altered. There wasn't so much drugs that you might suspect this person is selling drugs out of their car. There was no furtive movements or attempts to hide or conceal anything. There just was nothing there. All the officers confronted was two friends smoking marijuana, and everything they found was consistent with that. Sometimes a hunch is wrong. Sometimes a search does have to end because nothing further is found. And here, the police were only justified in searching the passenger compartment. They were not justified to go into the trunk and then a closed compartment in the trunk.
Okay. You wanted to just finish up with one more point and go ahead.
Yes, Your Honor, and I would just emphasize that the trajectory of the law is in favor of reaffirming the nexus requirement, of making sure that police action, especially when confronted with marijuana, is reasonable and tied in scope to the criminal activity suspected. And we know our state legislature has recognized that marijuana enforcement in particular has a disproportionate impact on Black and Brown and low-income communities with little benefit. And so here, even at the time that Mr. Ponder was arrested, our mayor was saying this enforcement needs to stop. We need to stop pulling over people and searching them on this basis. And so all of the broader context weighs in favor of affirming the nexus requirement and finding the search here overbroad. Thank you.
Thank you very much. You'll have 2 minutes for rebuttal. Thank you for your understanding today. Mr. Seawald, you have 6 minutes.
Good afternoon, Your Honors. May it please the court, Andrew Seawald for the people. It's long established that the police may search, and during a vehicle search, they may search any part of the vehicle that may contain evidence of the crime that they have probable cause to arrest someone for.
Mr. Seawald, I guess I was looking at Judge Farber's suppression decision, and he put in a footnote specifically that if this were a matter of first impression, he questions whether the odor of marijuana and the recovery of a small bag of marijuana from the center console of the car really provides probable cause to search closed containers in the trunk. Is it really likely that because someone is smoking marijuana in a car, they have a stash in a closed container in the trunk? Of course, he said went on to say this wasn't a case of first impression, and he made his decision accordingly. But the cases I mentioned to Ms. Francis before, Villette and Mina, are almost 11 years old, 10 or 11 years old. And is there been a change in the way we think of these things? And is that sort of what Judge Farber was hinting at in his footnote in his suppression decision?
I'm not sure exactly why Judge Farber felt the need to write that footnote. There really is not a...
I guess, he was thinking about it.
Sure, but, Villette and Mina are not that old, and there are cases from around the state that are more recent than that have reaffirmed the principle that an odor of marijuana emanating from a vehicle does give the police a basis to search every part of the vehicle that might contain marijuana, including the trunk. And, the trend, it's undeniable that there are shifting attitudes in society toward marijuana possession and marijuana use. And there are recent changes in the law by the legislature that have reflected those shifting attitudes. But the question is whether at the time Detective Tedeschi searched the trunk of this particular vehicle, he had a basis in the law. It was reasonable for him to do so. And as Judge Farber found, it was. And even if Judge Farber might have had some different personal opinion about how this sort of case could be analyzed, he properly found that he was bound to follow the law as it was. And
Counsel, sorry to interrupt you. Could Mena and Villette be distinguished, as your opponent suggests, because the handgun here, the Glock, was found inside a container inside the trunk? And we don't know if those facts existed in Mena and Villette, do we?
Well, no, but the distinction that the gun in this case was found inside a compartment in the trunk is not a meaningful distinction. And the police were entitled to search any part of the vehicle, including the trunk and including containers within the trunk or any other part of the vehicle, as long as those containers were containers that might have contained evidence of marijuana use. And Judge Farber was able to look at pictures of the container that carried a gun, and I think we could all agree that a container that can hold a gun could also hold evidence of marijuana use. And so that's really the question. And the distinction that this was a closed container within the trunk is not a meaningful distinction under the case law that allows the police to search any part of the vehicle, including containers, closed containers within the vehicle that might contain evidence of the crime. So, just because you have a fact-specific analysis in a Fourth Amendment case doesn't mean that we discard controlling precedent and that we think that any prior case that might have the smallest distinction is not relevant anymore, or is just distinguishable based on that minor difference. And here, under Villette, under Mena, the search by Tedeschi was proper. It was justified by the odor of marijuana. And then, unlike the cases that the defense relies upon, where such as Ramos or Romeo, where the evidence of the marijuana use was equivocal or was undermined by something that the officer found upon making the stop. Here, the officer was quite clear that it was a strong odor of marijuana. The defendant's own statement later on corroborated that he was smoking marijuana in the vehicle, and the officer found evidence of marijuana in the console of the vehicle. And so all of that provided him probable cause to search any part of the vehicle, including the trunk and including the container within the trunk where evidence of marijuana use might be found.
Okay. Thank you very much, Mr. Seawald. Ms. Francis, you have 2 minutes.
Thank you. Your Honors, this is a case that raises a lot of concerns. It's exactly what Judge Farber touched on in his decision. Upholding this search is counter to the direction that we're headed, and it's disturbing. What search wouldn't be upheld if uncorroborated marijuana smoke was enough to scour a car from top to bottom, including a closed compartment in the trunk. There would be no precedent in defendant's favor in this context if that were the case, and instead we see that there is. We see this court's decision in People v. Ramos, the Second Department's decision in Romeo, the 10th Circuit's decision in Downs. You know, none of these are controlling, but they're instructive. The rationale applies that there's no basis to suspect there's something going on with the trunk. You don't get to search the trunk. It's especially disturbing.
This is Judge Mazzarelli. I think I'm back on.
Yes, we see you, I think. I see you.
You say it's the laws change, but really it's not the law about that you have to have a predicate, some kind of predicate to search the car. It's really a cultural change with marijuana, not a conceptual change with what's needed to search all of the compartments in a car. Am I correct about that?
Correct. And the case law that we're relying on is very old. It's Supreme Court precedent in Ross itself. And when you look at the court's decision there.
So, but if we follow that line of reasoning, then if someone was shooting up, snorting up cocaine in the car, would that be a predicate for a search of the entire car?
Well, Your Honor, it depends on the circumstances the officers confronted in that case. And here, what we see is that the police did not have any basis to think that Mr. Ponder could access the trunk, that he had the time to hide drugs in the trunk between the smoke releasing into the air as the officer walked up and being pulled over. There was just nothing implicating the trunk. It's especially concerning that the police went so far here because what they thought they smelled initially, marijuana smoke, ended up being completely uncorroborated. There was no burning marijuana or ashes found in the car. They didn't say they saw Mr. Ponder or his passenger.
Marijuana that's around now has a particular odor that hangs around. I'm sure you know that. You can walk down, before the pandemic, you would walk down the street and you could get high at lunchtime, just smelling the air. And you know.
And it's equally possible that it was on Mr. Ponder's clothes, that other things, you know, in his car smelled like marijuana. But if they didn't find proof, they didn't find burning marijuana, then maybe that hunch, that smell was wrong and the search should have stopped. It's especially concerning because Detective Deteshi, you know, could have charged could have asked that Mr. Ponder be charged with a misdemeanor for burning marijuana in public. And the only charge he ever sought was marijuana possession, the violation. And so everything we see here is just inconsistent with this notion that there was a broader criminal enterprise or that Mr. Ponder was even actually smoking in the vehicle. And so for this basis, the search was overbroad and Mr. Ponder's convictions should be vacated and the indictment dismissed.
Okay, thank you very much, counsel. Sorry for the delay, but I think we got your arguments and we appreciate it. Have a nice afternoon.
Thank you so much. You as well.
I apologize to everyone for the delay. I have absolutely no idea what happened.
It's not your fault.
No worries.
All right, we're glad you're back on.
Thank you. Me too.
Okay, the next case for oral argument is Bortuno versus New York State Urban Development. The appellant is Schindler in this case, and Mr. Efron, you have 5 minutes.
Good afternoon, Your Honors. May it please the court, Steve Efron for the defendant's appellants, Schindler Elevator and Midland Elevator. I think a good starting point here is to note that this is in the court on a motion for summary judgment. The owner of the premises, Urban Development Corporation, moved for summary judgment addressing one issue only, and that was the issue of notice. And it established that it had no notice of any malfunction of the freight elevator on which the accident occurred. And in point of fact, Schindler had no notice of any malfunction either. But that, eliminating that one issue did not eliminate, as one must on a summary judgment motion, all issues of fact. UDC, Urban Development Corporation, did not address the use of a freight elevator for a purpose not intended, a passageway, and nor did it address the fact that it channeled the plaintiff to use this freight elevator improperly as a passageway by erecting a fence that cut off access, not completely, but for all practical purposes, access to the intended designed entranceway to the building. Schindler, in opposition to the motion, raised these issues, although I'm not quite sure that it was under an obligation to do so in light of the appellant's duty to eliminate all issues of that. Rather, the Urban Development Corporation's duty to eliminate.
Well, I mean, counsel, let me ask, wasn't there an obligation on the part of the elevator company, and weren't there statutes involved also that say that if somebody is walking, that in the event that they're going to come down and close, that a freight elevator is going to come down and close, there have to be alarms, there have to be some kind of notification instead of just fall down and hit the guy on the head without any notification. So whether there were, and then that was actually the cause of the accident.
Well, there can be more than one proximate cause. There's an issue of fact in the case. There's no question as to whether or not the audible and visual alarms were functioning at the time, and that would need to be tried by a jury. No question about it. But the notion adopted by the court that the fencing and the use of the freight elevator as a passageway and unintended use was a mere condition or an occasion of the accident, but not a cause, I think is incorrect. That doctrine, which started in the Court of Appeals with Sheehan against City of New York, applies to a situation where the alleged negligence is actually remote in time to the accident or is so distant as to be deemed not a cause of the accident. That's not the situation here. The accident occurred immediately upon the use of the elevator as a passageway. There's no remoteness in time here, it's contemporaneous. And the fencing, it was foreseeable and not remote that the fencing compelled the plaintiff to use the freight elevator as a passageway because there was no other safe access available to him. Of course, there could have been signage directing him to safe access, but there was no signage. There could have been signage warning him of the danger of using a freight elevator for other than its intended purpose, but there was no signage in that regard. These are issues of fact, and it goes beyond the mere condition or occasion of the accident. It's every bit as direct as a malfunction, an alleged malfunction, using the elevator for an improper purpose. And just as a procedural matter, the elevator company, Schindler, put in an expert affidavit outlining this, and that was never rebutted. The reply papers of the Urban Development Corporation did not include an expert, did not refute the expert opinion that this was a dangerous use of the elevator that could have been prevented very easily by permanently opening the doors, or if they didn't anticipate it being used this way, permanently closing the doors, or putting up signage, or appointing somebody with knowledge and experience, skill in operating freight elevators to be present during a use of the nature that occurred here. None of that was done, and these are issues of fact for a jury.
All right, thank you, Mr. Efron. You'll have a minute for rebuttal. May I hear from Mr. I'm sorry, I don't want to. How do you pronounce your last name? Yapchinik? Oh, you're on mute, sir. We can't hear you. I can't hear how you say your name.
I'm sorry, Your Honor. Can you hear me?
Yes, now I can hear you. Your name is Mr. Yapchinik?
That's correct, Your Honor. Yes.
Okay. Go ahead.
Thank you, Your Honor. Okay, I appreciate that. May it please the court, Christopher Yapchanik for the respondents, the Urban Development Corporation and Empire State Development. At bottom, this is just a case about the fact that plaintiff was injured by allegedly malfunctioning elevator doors.
Well, but I mean, excuse me, but to follow up from what Mr. Efron was arguing, I mean, the facts of this case are, yes, he's not saying, oh, we should be out of the case. He's just saying you should be back in. Yes, the elevator door fell and hit him. He was injured that way. But it's odd that you would need to walk through a freight elevator to get to the other side of the lobby or the building. And the reason was because you had erected a fence that required them to do that. So isn't that also a cause of the accident, on the theory that there certainly can be more than one cause of an injury in an accident?
No, because that's actually incorrect. The fence didn't cut off access. The fence did not prohibit anyone from using the passageway from the loading dock to get behind the elevators. The record has photographs at page 2047 that show that. The fence was erected to designate areas where the construction workers who were working to create the Moynihan train hall, where they should park, different from the loading dock elevators. But there was still access, applicable access from the loading dock to the hallway behind the elevators. The only thing the fence did was, if you were standing directly in front of the freight elevator, you couldn't sneak to your left to get into that passageway. You had to take about 10 to 15 steps backwards, then go around the end of the fence. There's a case cited in our brief, it's Caraballo, for this proposition. In that case, a building owner completely blocked access to a stairwell, and then the workers were injured when they had to use a fire escape as the only other means of egress. That's not the case here. The fence does not prevent access. It prevents immediate, quick, easy access. But if you're standing in the loading dock a few feet in front of the elevator, all you have to do is take a few steps to your left and go back to that passageway to access the hallway. The building manager from the state of New York testifies to that. He's actually asked the question, doesn't the fence prevent access? And he answers, and I'm paraphrasing, he answers, you can walk around the fence. So I would even concede Schindler's argument is much stronger if this fence completely blocks the access to the area of the building in question, but it doesn't. And
doesn't
even
block, just inconveniences them a little bit.
But an inconvenience doesn't make something impossible. And that the argument Schindler is raising essentially by saying in their brief, this greatly aggravated the situation, but greatly aggravated isn't a legal standard. What the out of possession owner requires is notice of the malfunction, and we don't have it. And then second, the argument is that we affirmatively created the only ability for plaintiff to access the other side. These elevators were dead. They were not used anymore. The fence only designated areas. It did not prevent access. So there's a difference between what Schindler is arguing and what the facts actually are.
Okay. Does anyone else have any questions for Mr. Yapchenik? Okay, well, thank you very much. Mr. Efron, you have a minute to respond. Yes, thank you.
Yeah, with respect to the argument that there was indeed an available safe access to the interior of the building, provided that the plaintiff stepped back some 15 feet and walked around the fence, all of that assumes that the plaintiff was aware that there was safer access, and that and on page 7 of our reply brief, we cite 2 cases from this court, Paget, which is a recent 2020 case, and Eisen against City of New York, a 1998 case, both of which indicate that the safe access has to be known to the plaintiff, and it's the defendant's burden to establish that that safer access was known to the plaintiff. And when one looks at the photographs in this case that Mr. Yapchenik referred to, there's no sign directing the plaintiff to the safe access. There's no indication that the route he took was anything other than the only route available to him. And quite frankly, I think Mr. Yapchenik has an argument that there is safe access and perhaps the plaintiff should have been aware of it, but that's the type of argument that clearly should be made to a jury and can't be resolved on a summary judgment motion. Thank you.
Okay, I think we have your arguments, counsel. Thank you both very much and have a nice afternoon. Thank you. The next case for argument is Rosenbaum versus Myers. Mr. Ali, is that how I pronounce your name?
Yes, Your Honor. Thank you.
Okay, you have 5 minutes.
Thank you, and good afternoon, Your Honors. May it please the court, Benjamin Ali on behalf of Plaintiff Appellant Rosenbaum. The complaint in this case sufficiently pleads a claim for breach of contract. It should be reinstated. The court below engaged in fact-finding. It drew inferences adverse to the plaintiff and found that a defense that the contract is unenforceable was supported by factual assertions by the defense.
May I ask a question here? Didn't one of the things that Judge Billings discussed in her opinion was the fact that there were certain allegations that you made in your complaint that you kind of stepped back from when you after they made a motion to dismiss. It sounded like in the complaint that your allegations were that you really had a lot to do with helping her resolve her divorce action, but afterwards you said, well, we really came in at the end. We weren't her divorce lawyer. There was an other of counsel. We really didn't have anything to do with that too much, because if you were the if you were actually the matrimonial attorney, then you would not be able to have this type of an agreement. So it seems like your factual allegations morphed after the complaint. I think that was one of the points that both the respondent and Judge Billings were talking about. If you could address that.
Yes, Your Honor, and Judge Billings did address that and did make that inference. It's not correct, however, and that's one of the problems with dismissing the case on the complaint and not allowing a factual record to develop. So we submitted the contract with the complaint. The contract sets forth the obligations of the parties, and it actually was drafted by the defendant, who's a lawyer herself and who was the plaintiff's ex-girlfriend for 15 years. And it actually described the past consideration, which was for multiple types of services rendered by plaintiff, her then boyfriend. The complaint includes allegations regarding both legal services, Your Honor, absolutely, and also other services. If you look at paragraph 15 of the complaint, for example. Once we got the motion from the defense in an affidavit.
Justice Moulton, doesn't that prove too much? Because the acknowledgement of debt also, it says it's for services in all litigation, which would include the matrimonial litigation. That was the main litigation at the time the AOD was entered into.
So, Your Honor, the acknowledgement of debt, just to quote it, it doesn't actually refer to litigation itself. And I think what Your Honor's looking at or referring to is the last sentence of the first paragraph. The debt arises as a consequence of extensive representation and advice in all legal proceedings and negotiations with various parties, the City of New York, and the financing and development of the property. And so the court below, relying on assertions in an affidavit from the defendant, just read out the last part of that portion of the contract. And so what we did in our submission and response is try to explain what those other services are, because this was not a case of a matrimonial lawyer providing services to a client under a retainer agreement.
But the complaint itself says, I'm quoting, the plaintiff stepped in to assist when defendant's previous lawyer, he provided advice. He appeared on defendant's behalf in the divorce proceeding. So if these legal proceedings even touch the matrimonial proceeding, and the matrimonial proceeding is even part of that, doesn't that mean that the various rules that apply to domestic relations matters would apply to your client here?
So Your Honor, the answer to that is yes and no. So first, it's undisputed that a portion of the services provided were legal services in a matrimonial action. And indeed, that's alleged in the complaint, and there's no dispute about that. But the question is the defense that the contract is unenforceable demonstrated and utterly refute allegations in the complaint otherwise, demonstrated conclusively by documents in the record? And the answer is clearly not. And so first, Your Honor, the question is, do those rules apply to this contract? And the answer is no. This was not a contract merely for legal services in a matrimonial action. This is not an action to recover legal fees. And this case is completely distinct and unrecognizable from prior cases where the defense of unenforceability was found. And ordinarily it's found at a summary judgment phase. That's because the contract here was provided and drafted by the defendant to her then boyfriend for a range of services arising out of her acquiring or related to her acquiring a very unique property, which was under a program called the Homeworks program. And Your Honor, I see my time has elapsed, but I'll just try to finish.
You can finish up and you'll have 2 minutes for rebuttal.
Thank you. If we'd had an opportunity to develop the record, which we should have had absent the fact finding and inferences, we would have shown how it was that the plaintiff provided a myriad range of services, some legal services and some very much not, to his then girlfriend, upon which she then provided him this contract. Thank you, Your Honor.
Okay. Thank you very much. Mr. Smith, on behalf of Ms. Myers.
Thank you, Your Honor.
Good afternoon.
I think it's a very clear case, and I'm going to try to show that by reading some what I think is fairly clear English, some of which Justice Moulton already read, which is in the record or in the law. And I'll start with a complaint because we are supposed to take the complaint as true on a Rule 3211 motion. And the complaint, Mr. Ali's complaint, says, quote, while the divorce was being negotiated, defendant's divorce lawyer ceased representing defendant. Thereafter, plaintiff, an acquaintance of defendant, who also happened to be a law professor, stepped in to assist defendant. Plaintiff provided advice to defendant, appeared on defendant's behalf in the divorce proceeding, assisted in negotiating the settlement, and helped obtain the favorable resolution of the proceedings, still quoting the complaint. Indeed, it was through his negotiating skills that 202 Lenox Avenue ended up in, it says plaintiff's, it means defendant's possession, as part of the equitable distribution of marital assets, end quote. And when he states his single cause of action on page 24 of the record, quote, plaintiff provided valuable assistance to defendant during her divorce proceeding, which resulted in defendant obtaining full title of the Lenox property, end quote. Quote, same page. Defendant agreed in the acknowledgement of debt that she was indebted to plaintiff for his invaluable assistance, guidance, lawyerly skill, and time, which enabled her to obtain the Lenox property rather than her ex-husband obtaining. And then the debt arises. This is from the now from the document itself, the agreement itself, the acknowledgement of debt. This debt arises as a consequence of the extensive representation and advice in all legal proceedings. And respectfully, the matrimonial case wasn't the main legal proceeding, it was the only one. There never was another legal proceeding. Advice in all legal proceedings and negotiations with various parties, the city of New York, and the financing and development of the property. And it's hard for me to see how Mr. Ali can say that his client isn't suing to collect for legal services in a matrimonial action. He's doing that. He did not file his retainer agreement with the court. The rules are just as clear as the facts. The law is just as clear as the facts. The rule says an attorney who undertakes to represent a party and enters into an arrangement for, charges or collects any fee from a client shall execute a written agreement with a client setting forth, et cetera, et cetera. The agreement shall, in actions in Supreme Court, a copy of the signed agreement shall be filed with the court with a statement of net worth.
Mr. Smith, this is Justice Shulman. I am mindful of the legal rules and regulations with respect to retainer agreements, but we cannot lose sight of the context of what was going on in 2004, 2005. They were in a relationship.
Yes, Your Honor.
Boyfriend, girlfriend. And we understand that when there's a familial or that kind of relationship, the normal business-like relationship that exists between a potential client and a lawyer is not quite the same. Also understand that we're dealing with a property in Harlem at the time. And again, I don't have all the circumstances behind the purchase of, dealing with the property and addressing the fact that there was a previous oral stipulation that allowed for the transfer of that property to your client, and understand that because it may have been a rent-regulated property with various other complicated Byzantine requirements that may have been necessary for her to own the property and perhaps eventually move into one of the apartments. I'm going a little fanciful here, but there's a lot more than just the divorce. And he, as a boyfriend, was a lot more than a lawyer to your client. And it's against that context and an unambiguous expressed AOD that she wrote as an attorney acknowledging that if and when this property is ever sold, I'm prepared at some future time to give a certain percentage of the proceeds for all that he has done for me 2004, 2005, and even beyond, notwithstanding that things went sour in I think 2015 before this litigation started. So would you not agree that it's a different kind of backdrop than the traditional retention that takes place between an attorney and a client that would trigger the underlying basis for the dismissal?
I agree that it's an unusual, not that unusual situation, Your Honor. I would respectfully disagree that it should make the plaintiff's case any better. And to me, it makes it worse. Where there is the whole point of these rules is to prevent the attorney from taking advantage of the client. Both these people had law degrees. Neither was a practicing lawyer. He was a law professor, and she was not in the legal profession at all. But you certainly cannot. I would urge you not to make a rule that says, "Oh, you don't have to file your agreement as long as you're in an intimate relationship with your client." To me, that's a reason for extra care. It is not a reason for less care. And in this case, when you look at the facts of this case, part of Mr. Ali's argument seems to be, well, this was for past consideration. This wasn't really a legal fee. This was a gift that Ms. Myers gave to Mr. Rosenbaum in gratitude. That opens such a huge loophole, Your Honor, especially when there's an intimate relationship.
Can I just ask you one more thing, Mr. Smith, because I know your time's almost up. Does it make any difference, or should it make any difference, that it appears that the oral stipulation of settlement between defendant and her former husband was entered into before this AOD was entered into? So he didn't even get involved, at least, I don't know about behind the scenes, but that this AOD did not get entered into until after that oral stip of settlement was done. And even though there was a written stip sometimes later, it really incorporated basically the terms of the oral stip. So should that affect it in any way?
No, Your Honor, because first of all, it's very explicitly alleged in the complaint that it was Mr. Rosenbaum who accomplished that stipulation. He takes credit and blaring the trumpets that it was his.
Even though there was another attorney that was officially a matrimonial attorney that was representing her during that period.
Yes, and what the complaint says about that other attorney is that he became unavailable, or he ceased representing her. That Mr. Rosenbaum stepped in to assist defendant, and that it was he who accomplished what happened in the stipulation. And indeed, I think the documents in the record that show that Mr. Rosenbaum was indeed of record in the proceeding by that time. It is true that the acknowledgement of debt was signed afterwards. That I don't think that matters. It especially doesn't matter, Your Honor, if I point out that it was an acknowledgement of debt. It was not a brand new contract. It was it purported to be a written acknowledgement of a debt that had long existed. So the inference is that contemporaneously with the services, she had an obligation to him, which she later recorded in writing. And in a lot of contexts, that's okay, but in matrimonial representation, it just isn't. You can't do it.
Thank you very much, Mr. Smith. I appreciate your answering those questions. And Mr. Ali, you have 2 minutes to rebut.
Thank you, Your Honor. There's not really a better example of the inferences being drawn against plaintiff in this case. And we just heard one. Mr. Smith just made up an inference about the acknowledgement of debt. And when you look at the timeline here, it's so important to answer Your Honor's question. The services provided here, the notion that plaintiff Rosenbaum, what he did was worse, is completely belied by the record. We should all be so lucky to get the treatment that the defendant got here. There was never any services provided for any compensation. The plaintiff was her boyfriend and helping her in all kinds of ways. This homeworks program is very difficult to navigate. Not clear if she would even want to be able to get the property, be able to get a loan, be able to get the tax benefits. Rosenbaum helped in myriad ways. After that, and after she had the property, directly to your question, Your Honor, Justice Kapnick, then she, of her own accord, drafted and provided this document to him, acknowledging the past consideration, and it's thereby not a gift, and awarding him 1/4 of the profit. And she then reneged on that agreement several years later after they lived in the home and kept $4 million in proceeds for herself. This case, as Justice Shulman said, is nothing like anything you'll find in your precedents. There is absolutely no way it should have been dismissed on the pleadings without the development of a record. I just had one last point. I see that my time is run, and I know counsel also went a little over, but it was dismissed on documentary evidence. The documentary evidence wasn't put in. We don't have the record from the divorce action. We don't know what was filed there. Defendant had 2 other lawyers. We don't know whether there was a violation of the rules, whether it was substantial. Judge Billings relied, it appears, on the affidavit of defendant, and that's not permissible at the pleading stage. Thank you, Your Honor. I appreciate it.
Thank you both very much, and have a good afternoon. Thank you for the arguments. We'll take another look at those papers. Okay, the next case for oral argument is Lynn versus the Department of Education. Mr. Lynn, I see you there. Yes. Okay, and you have 6 minutes to argue, so you may begin now. Thank you. Go right ahead.
May it please the court. This is Fong Lin on behalf of petitioner appellant IBH Lin. Now that respondent have conceded that the first cause of action was not premature after all, the issue of the first cause of action boils down to this basic question. Did the evaluation process of the respondent have the needed integrity of any valid, legitimate evaluation? Petitioner would like to submit there was not, it did not. I can use one episode to explain without a scintilla of doubt. The respondent's evaluation process was a bogus process to reach the predetermined result. That's called filing of the petition. Now, consider this fact. In New Utrecht High School, the school's records show any teacher whose test observation was evaluated, was observed, received unsatisfactory rating, and soon afterward, the teacher either got fired or have to leave voluntarily. So that was
Mr. Lin, this is Justice Moulton. Can I ask you a question about the previous assignment at Long Island City High School? Because, you assert, of course, that the reason that the petitioner didn't get tenure there was because it was found to be a school, I don't know the correct term, a failing school, or a term that was a turnaround school. However, the respondents say to that, no, in fact, many teachers that year at Long Island, at that high school, did receive tenure, despite the fact that it was designated a turnaround school. Can you respond to that?
Okay, let me say that. How true was the New York City's assertion? You wasn't verified, but all we know, just based on the list they provided, none of the teacher was a science teacher. Okay, and the science teacher and then a petitioner was accessed very soon afterward. So it was unlikely they would grant a teacher to be accessed soon afterward and then say, we'll give it the tenure. So there was that result. By the way, even though, assuming whatever the respondent said was true, there was still an issue. Regardless, Ms. Lin's last supervisor summarized her performance this way. Overall, Ms. Lin did a very good job, and he recommended tenure. There was no doubt about it. So even though that tenure recommendation wasn't accepted by the higher up for whatever reason, but that did not tarnish Ms. Lin's ability as a teacher.
Well, Mr. Lin, is it fair to say that I know her annual reports were all satisfactory at the previous high school, but there were classroom observations where she was criticized for similar things that she was criticized for at New Utrecht, i.e. the students' use of cell phones and their inability to control the class. So doesn't that show that perhaps the New Utrecht criticisms were not simply a vendetta against her?
A few issues. First, about the cell phone. Okay, if you look at all her prior schools record, cell phone was never mentioned, and the cell phone issue wasn't presented even before the region exam. So all of a sudden, cell phone popped up all over, almost phenomenal, and the missing supervisors report did not include one single identity of the student. And by the way, if you go through the whatever report, anytime when there was a cell phone, Miss Dean did her hardest try to do it. As a matter of fact, Miss Dean was the only teacher who tried to enforce the Chancellor's law, Chancellor's rule 412, I believe, and the assistant principal freely allowed students to use cell phone in his office, and that was recorded in Ms. Dean's letter to assistant principal. And the principal herself did not even know she had the authority to permit students to carry the cell phone into the school for medical reasons. So the entire record shows Ms. Dean was the only teacher who tried to enforce the law, enforce the rule. Just like she was the only teacher trying to enforce the region exam rule. Everyone else thought was not a big deal. Don't make a fuss about it. So that's my answer. Okay. By the way, I believe you also had another question. May I? I get lost track. What is the other one? May I ask?
No, I had no further question.
Okay, Mr. Lin, you've had 6 minutes, so I'm going to listen to the other attorney, and then you have 2 minutes for rebuttal after that. Okay?
Okay. Thank you.
Thank you. Thank you. Counsel, I'm sorry. How do you pronounce your name?
Wamaka Ajibi.
Ajibi. Ms. Ajibi, you may proceed. Thank you.
Thank you, Your Honors, and good afternoon. May it please the court. My name is Wamaka Ajibi, and I'm appearing on behalf of respondents and cross-appellants to the New York City Department of Education, Chancellor Walcott and Superintendent Horowitz. Appellant was a probationary teacher for 6 years, and during that time, she taught at 4 schools. At each of Appellant's last 3 schools, she received multiple unsatisfactory or marginally satisfactory classroom observation reports. The heart of many of these criticisms were the same. Appellant's classrooms were, quote, chaotic, unquote. She had significant weaknesses in classroom management and student engagement. Given this record, it was surprising that Appellant never granted tenure at any of the schools, and her probation still had to be. Appellant was granted multiple opportunities to show that she could grow as a teacher and create a positive and enriching environment for her students. The record shows that she got support from her administrators at Utrecht and administrators at other schools. Weekly meetings with assistant principals to learn to craft her lesson plans and to discuss teaching strategies. A log of assistance so she could learn from senior teachers. And yet she was unable to grow. The documentary evidence establishes that the DOE had a good faith and non-retaliatory reason for Appellant's discontinuance. Given the importance of ensuring quality teaching and ensuring the growth of students in the district, the superintendent has wide discretion to
Counsel,
fire or.
I'm sorry to interrupt you. One thing that disturbs me, and that might, one could argue should lead to a hearing, is the allegation by the petitioner that Principal Goldfarb told that she was under orders to gather evidence against petitioner. And that was in the meeting sometime in March. Now I know that Goldfarb said she hadn't heard about the alleged cheating incident in January until much later. so it hadn't at this point. But how do you respond to that? I mean, that sounds pretty bad, doesn't it?
Well, if the order was in order to establish her observations of the teaching, there's multiple ways it can be interpreted. But ultimately, it's a question: is that a material fact that would prevent the DOE from getting summary judgment? And we say here, no. As long as there is good faith on the record, that's enough to defeat any allegation of bad faith. And here we think that the good faith evidence is overwhelming. Even before you get to that meeting, that supposed April 2nd meeting, there was already clear that there was documentary concerns at Utrecht and at the other schools of Miss Lynn's deficiencies with classroom management. On the issue of the whistleblower allegation, the DOE submits that the Supreme Court erred in not granting summary judgment on the issue for two main reasons. First, the lower court put misplaced a reliance on Court of Appeals decision on Kowalowicz. The lower court read Kowalowicz to mean that if there's a disputed fact about an employer's motivation to terminate the employee, then summary judgment should be denied. We read that case completely differently. In that case, the Court of Appeals was dealing with a different factual issue. There was an arbitrator in that case who determined that the CBA at issue didn't grant him the authority to consider an employee's civil servant whistleblower Article 75B affirmative defense. And therefore, he only considered that issue when it came to questions of credibility. And the Court of Appeal said that was wrong, and that the arbitrator should have, quote, made a separate determination, unquote, as to whether the retaliatory motive was the basis of the disciplinary action. So the case was really about the ambit and the of the arbitrator, but some court, including the lower court here, took that separate determination language to mean that if there's a disputed fact about the employee's motivation, then summary judgment can't be granted. We think that's the wrong reading for a few reasons. At first, it's at odds with the specific language of the statute. Section 75B, subsection 4 says that, quote, nothing in the section shall be deemed to prohibit any personnel action that would otherwise have been taken regardless of any disclosure of information, unquote. So if a separate and independent reason for determination is not sufficient to defeat the claim, that would render that language of the statute completely inoperative.
But does that lead to the possible danger that assistant principals and principals will simply paper up and, if they're well advised, figure out pretexts and document them? And then how are you going to know? How will a reviewing court understand whether or not it was a pretext?
That is certainly a danger in the way that the statute is written, but we think that the way that this court has applied the statute, most recently in Ten and Ben, that's just the way it's supposed to be interpreted. If there is an independent and separate basis, that's sufficient to defeat the claim.
Okay, we've given you the 5 minutes. And you reserved a minute for rebuttal, okay? So you'll be able to come back after Mr. Lin speaks. Okay, so Mr. Lin, you have 2 minutes for rebuttal of anything that you'd like to add.
First, I'd like to address the prior question Honorable Judge Moulton asked, okay, raised about her petitioner prior full school. We admit petitioner was at least she was an outstanding, a very good teacher in the Bronx. When she moved to the Queens, the culture of the school may be different, but whatever her supervisor in the Queens found, deficiency found, petitioner overcame it. At the end, they all turn around. They all like him, like her. Okay, so I believe if the respondent want to say anything about at least prior record was a wash. Okay, now I like to go back to the case Kowalewski's Stanford. I believe no one would dispute Kowalewski Stanford pretextual firing termination was unacceptable, no matter it's arbitration or what. And this is the whole case is all about. Now, I like to also address the so-called independent basis of filing or good faith. But actually, if you closely examine every document, the thing they rely on for good faith argument actually was bad faith. Every document there, I can point out there are so many not just error, intentional misstatement in those records. Just take the two examination. The first two. Assistant Principal AP, frankly admit he spiked it up because the previous version, the principal did not like it that much. So, and the things mentioned in that report could not happen. Can anyone imagine? Two assistant principals standing in a room behind, and there were still 5 students frantically trying to cheat. How could that possibly happen? And then, by the way, the assistant principal in the memo, in the report, also indicate petitioner expressed he has seen some evidence petitioner was teaching and trying to get was teaching and teaching or something. Now that was a test. No teaching could ever take place. I think so. Every memo. And by the way, petitioner rebut every negative observation, every disciplinary charges. But the funny thing was the respondent, principal and AP, even before petitioner wrote a letter, when they wrote a report on test examination or lesson observation, simultaneously, they also have an agreement between the two, have a compact between the two, say we should never read those rebuttal. And by the way, we should not send it to the superintendent. So whatever Ms. Lin wrote could not see the light of the day. I would like to use one analogy, analogous situation.
And then just finish up. That's the last thing. Okay.
Okay. Sorry, that will be longer than probably 10 seconds.
That's okay.
But I will try. That's almost superintendent and AP as a task force to try to evaluate a person. But before they have conducted evaluation, they already have a conclusion. So they poke around, try to find whatever can fit. If that cannot fit, they create something to mess it, try to cover it, try to make it look natural. But I would say.
I think we understand the points, and I thank you very much, Mr. Lin, for your argument. Mr. GB, you have 1 minute for any rebuttal you would like to make on your cross appeal. Okay.
Your Honor, to make one point, just about the lack of motivation. Appellant offers a lot of theories as to exactly how different students or administrators or other DOF officials work together to conspire against her. And there's no evidence in the record that any of these people would have a motivation to put together an elaborate scheme to get her discontinued. And with that, unless there are further questions, the respondents would rest on their briefs.
Okay. Thank you both very much. We'll take another look at all these papers. Have a good afternoon and thank you.
Thank you.
The next case for argument is Jackson versus 160 West End. Each side has 5 minutes on this case. Ms. Ayala.
Thank you, Your Honor. May it please the court, my name is Yolanda Ayala. I represent the defendants in this matter. It's the defendant's contention that the trial court properly granted its motion to amend the defendant's answer to deny ownership and improperly granted plaintiff's cross motion to amend its complaint to name the Board of Managers as a direct defendant after the expiration of the statute of limitations. At the outset, it must be emphasized that the respondent in her brief admits she was well aware of the legion of cases that hold the Board of Managers is the only entity that can be legally liable for injuries sustained in the common areas of a condo complex. Nevertheless, she suggests that she was not bound by that case law because she was entitled to rely on the defendant's judicial admissions as to the ownership contained in its initial answers. This argument is without merit because the law is clear that admissions and pleadings will only be conclusive if and only if the party never seeks to amend its pleading, which clearly did not occur here. Furthermore, the record reveals.
Excuse me, Ms. Ayala, but didn't you wait until the statute of limitations had expired to make your motion? I mean, wouldn't you call that a little bit of prejudice there?
Your Honor, I would say there was no prejudice because there was a 10-month period. I'm sorry, did you say something?
No, go ahead.
There was a 10-month period between the time first service witness was deposed and the expiration of the statute of limitation. The first service witness clearly indicated that the Board of Managers owned the driveway in question. And in fact, after the deposition, the attorney that handled the deposition for the plaintiff at that time told the defense counsel, hey, I want to amend, I'll send you a stipulation. And they did nothing. They sat on their hands.
Apparently, with hindsight, we now see that the attorney that was handling the case may have left the office. It may have been an error that they didn't do it. But your client still knew. You were at the deposition also. You knew what your client said. And why couldn't you have moved to amend once you knew, even if they didn't send a stipulation or follow up and say, hey, guys, where's the stipulation? I mean, might have been a little bit of dilatory action on both sides.
Well, I suppose we could have woke up plaintiff to try to amend their complaint. But again, if counsel has admitted that she was well aware of the law, that the Board of Managers in condo complex cases is the appropriate entity, even before the deposition, even before the complaint was filed, they should have named the Board of Managers as a defendant, regardless of any action or inaction of the defendant.
Okay. Anything else?
The trial court's finding in terms of unity of interest between First Service and the Board of Managers was also erroneous. As discussed in the cases cited in our brief, united in interest means that both defendants need to stand or fall together with respect to plaintiff's claim. Therefore, the test is not whether the defendants will assert different defenses, but rather whether they could assert different defenses. The plaintiff is claiming that since First Service and the Board of Managers can both defend on the same theory, that is that they properly maintain the driveway, they're united in interest, but that's not so. Plaintiff ignores the fact that First Service could also claim that it is not the property owner and lacks exclusive control of the driveway, which obviously is not available to the Board of Managers. Accordingly, their defenses are not identical, but rather divergent. Lastly, although the lower court refused to find unity of interest between the Board of Managers and First Service, the plaintiff nevertheless claims that such a finding should have been made because 170 Owners Co. executed a contract for the repair of the area. Again, plaintiff ignores the testimony of First Service witness who explained 170 was responsible for repairing the driveway as part of its common area expenses. But the Board of Managers at all times retained ownership and maintenance obligations for the driveway. Under these circumstances, the trial court properly found that the Board of Managers in 170 was not united in interest because 170 could deny ownership and maintenance, whereas the Board of Managers cannot. There's no further questions. I'll rest on my brief. Thank you.
Thank you, Ms. Ayala. Ms. Hasapides, good afternoon. You have 5 minutes.
Good afternoon. May it please the court. Minette Hasapides appearing for the plaintiff in this case. It's ironic here that the defendants have appealed. The defendants made 2 binding judicial admissions and 2 answers over a period of years, and appeared at 2 compliance conferences without once raising an issue about who the proper owner was in this case. And they seek to shift the burden to the plaintiff. Once we had the admission in not 1 answer, but 2 answers, we had no obligation to do anything else. The issue was decided and it was conclusive. To argue that we had an obligation to ask the defendants if they wanted to change their position is really disingenuous in terms of the way the litigation proceeds. We had no reason to conduct any discovery on ownership, and it's one of the reasons why, the arguments about who owned this driveway can be characterized as clear as mud in some respects, because Ms. Burke's testimony contradicts the declaration. The argument that Ms. Burke testified that the Board of Managers owned the area is defied by the declaration. I'd refer the court to page 181 of the record, where it indicates that the units include the appurtenant driveways. Page 183 of the record says that the common elements include the driveways that are not part of a unit. And page 185 says the common elements are not subject to partition and are not severable from the units. So Owners Corp. Owned the driveway, according to the declaration here. Owners Corp. Was united in interest with the Board of Managers. The defendants agree that the Board of Managers is an owner. I had agreed with the lower court that First Service and Owners Corp. Stand and fall together because they both acknowledged through Ms. Burke's testimony that they are responsible for the maintenance and the repair of the area. Another fact to consider with respect to Owners Corp. Responsibility and defendants' argument that only the Board of Managers can sue on behalf of this cond op is the fact that Owners Corp. Sued the paving contractor for breaching the paving contract. Why didn't the Board of Managers do that? If, in fact, the Board of Managers is the only entity that can be sued with respect to incidents and events occurring on the property. I'd like to pivot briefly with my remaining time to our cross appeal. It's ironic that we were not the main appellant. We cross appealed because they appealed this issue of relation back. Here you have us relying on 2 binding judicial admissions for a period of years. Depositions occurred. Ms. Burke's testimony did not plainly state anything with respect to ownership, certainly not enough to refute 2 binding admissions of ownership. The case law in the 1st, 2nd, and 3rd departments is unanimous, especially the 1st department case, and I know it's 1925, but it was a premises liability case where the property owner, after the statute of limitations had passed, moved to amend the answer to withdraw the admission of ownership, and this court said that it would work an injustice. Frankly, the language of concern with respect to the lower court's order is that at page 11, not page 11, excuse me, at page 10, the lower court said that whether plaintiff could amend her complaint is immaterial to whether plaintiff would be prejudiced by allowing defendants leave to amend their answer after the statute of limitations occurred. With all due respect, that is contradictory to the unanimous authority of the 1st, 2nd, and 3rd departments. So if this court were to modify any portion of the lower court's determination, plaintiff submits, it should be to deny the defendant's application to amend their answer after the statute of limitations expired. If there are no questions, I'd rest on the brief.
Okay, thank you very much. I think we got the arguments on both sides. Thank you both very much. Have a nice afternoon.
Thank you, Your Honor.
Thank you.
And I believe the last case for oral argument is Trinity versus MTA New York City Transit. So counsel for MTA and New York City Transit, I think you are the appellant. So you go first.
Yes, thank you, Your Honor. John Nikolic for MTA and New York City Transit. This appeal primarily concerns the construction and application of Section 1266-12 of the Public Authorities Law. And this is an issue of great importance to the MTA and the Transit Authority because the trial court's narrow construction of this provision basically cripples the ability of the MTA and the Transit Authority to proceed with projects for the installation of ADA accessible improvements to transit facilities in New York City, and particularly under the New York City zoning resolution, where the Transit Authority in New York City work together with developers who agree to pay for and install these types of improvements. Now, the section provides clearly MTA may, upon suitable notice to and an offer to consult with an officer designated by the City of New York, occupy the streets of the City of New York for the purpose of doing any work over and or under the same in connection with the improvement, construction, reconstruction, or rehabilitation of a transportation facility without the consent of or payment to such city.
Counsel, that does, this is Justice Moulton, that does articulate a fairly plenary power to your client. But I'm wondering, how long can they dominate this piece of sidewalk? And in particular, I want to ask one question, which is, why was it Trinity's responsibility pursuant to its agreement? And then 2 years later, it became TPH Greenwich's responsibility to do the elevator. And doesn't this all cause a great deal of delay over a very contested, very small but important piece of real estate, i.e. the sidewalk? Well, in other words, the delay was so long, it's prejudicing a lot of people. And part of the delay, I don't know, does it arise from the fact that you then could, you went from one developer to another to build the elevator?
No, it has nothing to do with that. Now, the reason, there are underlying reasons why it went from Trinity to 42 Trinity. There were some conduits and things like that that created some construction difficulties. But that's really irrelevant to the situation we're at today, because this agreement with 42 Trinity was entered into several years ago, and 50 Trinity knew about that situation for a long time, and they had the ability to deal with this situation. When they applied for their original permit, it was only going to be until April 2019, and they knew that 42 Trinity was going to need to get onto the sidewalk within the next year or so. And 50 Trinity had the ability to make different arrangements that would allow 42 Trinity to do that. Their permits from DOT expired originally in April of 2019. That's what they asked for. Now, there's been a number of things in the record showing that 50 Trinity could have made different arrangements in order to allow us to get on the sidewalk. In particular, and this is even attached to their petition, there's communications with DOB where they submitted very late in the game, that was their fault, not ours, an amended site safety plan. And DOB said that, yes, they had some objections to it, but they had nothing to do with what was characterized as the MTA zone, the sidewalk that we needed in order to do the elevator. And they've made no efforts in order to address those objections, so they're still stuck with having their stuff on the sidewalk. And another thing I would point out, and it's in the record, we didn't mention it in our briefs, but 50 Trinity's contractor, Rinaldi, actually sent a letter to their client talking about alternatives. And at page 535 of the record, there's a reference to what they call a needle beam cantilever overhead bridge. So that was another item that they could have and should have planned to do in order to allow us to get onto the sidewalk to do this project.
Mr. Nicholas, what was the story about the transit authorities having issued a stop work order to Rinaldi, and does that affect any of this? Because it doesn't seem that the court has the right to consider the validity of a stop work order issued by the transit authority. It seems like they have to litigate or figure that out. So how does that affect all the timing and situation amongst the parties here?
Well, other than the fact that, this is one of the items where 50 Trinity just disobeyed and disregarded it. We have not afterwards tried to enforce it. What we did was when they disobeyed it, we went into court in order to get injunctive relief to get them off of the property. So we didn't try to go in and otherwise enforce that order.
Okay.
All right. So as a matter of statutory construction, there are a couple of key phrases in that in the public authorities law. One is it refers for the purpose of doing any work. That's a very broad phrase, and the trial court went off and said this does not apply to the MTA because the MTA in this case is not doing the work. But the MTA doesn't do the work. They contract with contractors to do the work. And in this case, they contracted with a developer who contracted with a contractor to do the work. So, to say that because the MTA is not doing the work, the statute doesn't apply is just misconstruing the statute, which is broadly worded. The statute also has the language about in connection with, and we've cited Court of Appeals cases saying that's a broad phrase. So the MTA is trying to get this sidewalk in connection with the work that New York City Transit has contracted with the developer to have this done.
All right. Can you just finish up because you're kind of over your time and you'll have 2 minutes rebuttal. So if you have something else.
The only thing I would point out, there are a lot of issues in the case. I'm sure you read the briefs, but this case is very similar to the MacArthur Properties case that Justice Schulman decided, and this court affirmed on his decision. We don't see any material difference between these cases. Thank you very much.
Thank you very much. We'll now hear from the attorney for Trinity, Mr. Freed, right? Who's going to steal a couple of Mr. Jacobs' minutes if he needs them. Okay.
Thank you, Your Honor. I just want to make 2 quick points to start, which are important, and I'll move into more substantive issues. Number 1, despite the MTA's attempt to change this, they have the burden of proof here to demonstrate the trial court erred. They've attempted to argue that it's my burden to show you that the trial court was correct. That's not how it works, and they've woefully failed to do that. Second, Mr. Nicholas just argued, and they've continued to spout this argument that this is a case about the MTA's efforts to make a subway station ADA compliant. That is not what this case is about. It's not even close. And I would note that without my client's hotel project, we wouldn't even be talking about this because the only reason they're doing this subway station is because of our project. But I really want to talk about 3 arguments we've raised and in our briefs that the MTA has not even responded to. And they're critical. Number 1, we've suggested they should go to the legislature if they want to expand the use of 1266 of the public authorities laws. And the reason we suggested that is they did that very thing in April of 2020 when they sought to expand the very same statute, and they got that in the legislature. They haven't responded to that argument because they don't have a response. The second argument we've raised, and it was noted by the trial court, is if the MTA's reading of this section were to be correct, it would result in utter chaos in the real estate development world of New York City. So anytime any developer wants to curry favor with the MTA, they'll say, you know, I'll do this and can you put me to the head of the line? So for example, Your Honors, what if my client says, you know what, we'll put an elevator in on the other side of the street. Can we now get in front of the other developer first? They don't respond to that. And by the way, that actually explains why they should go to the legislature, because to avoid the kind of chaos that would inevitably result, the legislature can deal with that. They don't have a response to that. Third, maybe most obvious is we have a letter from the MTA, record site 1297, in which they say, we will not interfere with your project. We've said that in our briefs. We've said it to them. We pointed it out to the trial court. They have no response. They can't respond to it because they are interfering. And in fact, as you probably know from our papers, Your Honors, they've continued to interfere with our project in the face of 2 separate injunctions against them. I just want to make a couple of quick comments about the statute, because you asked Mr. Nikolic some comments, and he pointed out that Judge Shulman dealt with this in the MacArthur case. This is nothing like the MacArthur case. The most obvious difference is the MacArthur case was an MTA project on the 2nd Avenue subway line. I was going to save this for last, but I have to say this now. You can go on the internet and see a list of the MTA capital projects. Anyone can do it. Any of you, I've done it. So in the MacArthur case, for example, had you looked, you would see that the 2nd Avenue subway line's a capital improvement project. And the subway stations that the MTA intends to improve for ADA compliance are listed on that website. It's amazing. This subway station is not listed as an MTA capital project. And the reason it's not listed is it's not an MTA project. They have nothing to do with this project. All it is they are getting a developer to build them an elevator. That's fine. You pointed out, Judge, earlier about the delays. We would be done by now if they had just let us do our project. But I want to point out one thing about 1266. When you look at the legislative history, it is clearly a statute that is intended for the following. I'll read to you. It is designed to speed up public works projects that were being publicly funded and being managed and completed by city agencies on public dollars. Well, none of those things apply here. This is not a public improvement project. There's no public dollars being used. The MTA is not doing anything on the project, and it's not being completed by a city agency. In MacArthur, it was the 2nd Avenue subway line, an MTA capital project being done by the MTA with their contractor, not a private developer doing the work with private dollars.
Mr. Freed, excuse me, but isn't there an agreement, a contractual agreement between New York City Transit and 42 developers, the 42 Trinity, the other one, to do this very project that will benefit the public, the ridership, the ADA, the people who require an elevator to go up and down. And yes, I'm not unmindful of the fact that most of the stations don't have elevators. I got all that, and much of the points that you're making here, I read in your brief. But that is a contract that clearly benefits the public. That is a contract that clearly involves a public authority negotiating with a private developer to get something done for the public. It makes no difference whether the funds come from tax dollars or from private developer dollars. That is a public works project.
It does make a difference.
So therefore, while I'm mindful of the factual distinction between MacArthur and here, in that sense, it doesn't detract from the fact that this is a public works project. The elevator is not benefiting the private developer, it's benefiting the ridership. Exactly what the MTA and its cousin, the New York City Transit, negotiated here with. And the plans being used are MTA plans. They're not
No,
private.
that's not correct, Your Honor. With all due respect, they are not MTA plans. And I would like to respond. First of all, my client also has a contract to do work that's going to benefit the public.
I know the
You
room.
understand- But Judge, we were going to do the elevator, and now the other developer is doing the elevator, so they want to move them to the front of the line, which is exactly, Judge, we wouldn't be having this argument if the MTA wasn't standing on 1266. I have no disagreement with you that this will benefit the public. What I'm suggesting to you is if they're going to rely on 1266, which is what they did, the way we got here is our permits were held up because of a 1266 letter. Without that, we'd be done now. So if they were just arguing this is a public improvement project, be a different story. What they've done here is what they're saying is under this statute, we get to do this. But that's not true, Judge, because what they're really doing is they're enforcing the zoning resolution, which requires a developer that's building a project near a subway station to give something back. That's fine, except that that zoning resolution came out 4 years after this statute that they're relying on. And this statute was not written with something that hadn't been developed yet in mind. And all I'm suggesting to you is not that it's not a public improvement, it most certainly is to some degree, but they're not using public dollars, which is what 1266 is designed for. And they're using 1266 to stop my client from doing its project. So I think we agree, basically what you said is, yes, this is going to assist the public. No question, and we are very much in favor of that. That's why my client was originally going to put the elevator in itself. I'm just saying that if you can't use 1266 for what they're trying to use it for. And Judge, I'll leave you with this. They can, if they go to the legislature and have the legislature amend the statute to give them that right, because then they could deal with the fact that they could work with the legislature to provide language in the statute that prevents the chaos that would result. They've done this before, Judge. They did it in April of 2020 when they amended the statute. Why aren't they doing it now? That maybe Mr. Nikolic can give you an answer, because he certainly didn't do it in his briefs.
Okay.
Are there any other questions?
Thank you, Mr. Freed. Well, theoretically, he stole all your time, but I'll give you 2 minutes, Mr. Jacobs. You're on mute. We can't hear you.
I apologize for that. Thank you.
Now, you represent Rinaldi, who, if I understand correctly, is no longer on the site.
Well, that's exactly the case. That's the point I made in a very limited brief.
Right.
While we incorporate the arguments from Trinity, we're not on site anymore. We don't have any property on site. MTA knows we're not on site. They referenced that the permits were canceled in on June 19th of 2020. Yet it brought the appeal against Rinaldi, dragging Rinaldi continually through this fight that it has with Trinity. We don't belong here. The court ruling on this would have no effect because because Rinaldi is not on site anymore. And so that's the point, and that I wish to bring to the court. And I think it's really the most important point as to Rinaldi, because we just don't belong here.
Yes, I think we read that in your brief. So if there's nothing else, then good that you ceded your time to Mr. Freed. And now, Mr. Nikolic, you have 2 minutes to respond.
Well, if I had any more, sorry, thank you.
You're very welcome. Thank you.
Thank you, Your Honor. I just want to address briefly the points that Mr. Freed made. He said that we have the burden of proof to show the trial court erred. I think we show that very clearly just as a matter of statutory construction. And they did not address any of our cases about statutory construction, where here the trial court added provisions to the statute that just don't exist. Mr. Freed says we have no answer, that we should have gone to the legislature. We don't need to go to the legislature if the statute is clear on the face and gives us the power that we need. He talks about chaos. He's talking about hypotheticals that are not present here. This is not an issue that this court needs to address. In terms of the letter that he referred to on page 1297, he says something about that we would not interfere. What the letter actually says is, we acknowledge that under this plan, developer may proceed with construction on its own schedule and is not required to halt or speed up construction based on the installation schedule of the new elevator. We're not asking them to halt or speed up their own construction. We're just asking them to get off the sidewalk and let us be there, which they could have done had they made alternative plans for this cantilever type overhead protection. He talks about how, well, it only applies if there's a capital project and public dollars. That is not in the statute. That's very clear. He's trying to add provisions to the statute that the legislature did not enact. Same thing about legislative history about this has to be public funding. Public funding is not a requirement of the statute. So, and about getting to the front of the line, we're not trying to get to the front of the line. We just want to obey the statute. They could have taken their alternative steps in order to allow us to get on the property, dealt with the DOB objections. They've totally refused to do so. Thank you, Your Honor.
Anyone have any questions? All right, well, we will go back and look at all these issues. I thank you all very much for your time and for your effort. So this is the last case that was being argued today, and this concludes the oral arguments. Court is now adjourned, and thank you all very much. I don't have to say get home safely. You're probably there already. So have a nice evening.
Thank you, Your Honor.
Bye-bye now.